Good morning, everyone. On behalf of MIT School of Architecture and Planning, I, Dr. Snigdha Chaudhary, welcome you all to the final day of the Faculty Development Program. We begin with the session on IPR Fundamentals, Patent Process and Research Translations by Dr. Harish Sharma, Deputy Manager from MIT Intellectual Property Right IPR Cell and a Certified Intellectual Property Trainer at MIT University, Noida. Sir possesses extensive certified property expertise in the domain of IPR rights, patent filing, innovation management, and technology commercialization. With the significant experience in the guiding academicians, researchers, and the innovations, Harish Sir has been actively involved in promoting awareness and understanding of the IPR protection and patent strategies. His work primarily focuses on helping researchers identifying patentable ideas, develop innovation-oriented research outcomes, and the procedural framework of patent filing and commercialization. He has contributed towards fostering a culture of research, innovation, and intellectual property awareness with academic and professional involvement through workshop, training program, and expert sessions. His insights into innovation management and IPR process continue to support researchers in translating ideas into the impactful and protected intellectual assets. I will invite Dr. Harish Sharma to take over the proceedings. So please.
Thank you so much for inviting me, Dr. Snigdha ma'am. And as she's already introduced me, Dr. Harish Sharma, registered patent attorney and facilitator, working in MIT IPR cell as an deputy manager. So today we will discuss about IPR fundamentals, patent process, and research translation. So basically, in Indian IPR system, we have 7 IPR. Firstly, we will start with definition of IPR, intellectual property right. So any property that is created through human mind is known as intellectual property. The moment we register that property, it becomes IPR, intellectual property right. So in this session, we will cover IPR fundamentals, the patent system, patent filing process, and research translation. So basically, why does IPR matter? Because when any inventor, any creator, any innovator invents something that is having some uniqueness and novelty and spends lot of time, lot of money, so there should be some reward for that innovation. So to protect the inventor's right, we have this idea, this concept, intellectual property right. So total we have 7 kind of intellectual property. All intellectual property have their own act, their own rules and regulation, their own criteria for grant. Once the all examination has been done, according to that, creator innovators get the rewards in the form of registration, in the form of grant certificate. So why basically IPR matters? To encourage the innovator, to encourage the inventor, so that no one can copy his her invention without his or her prior permission. We have this concept IPR filing, and so that no one can import, sell, manufacture without prior permission of inventor or innovator. So as I told you, we have total 7 IPR in Indian IPR system. So here we are mentioning 6 IPRs: patents, trademarks, copyrights, designs, geographical indication, plant varieties, and the seventh one is trade secret. Actually, 7 trade secrets I didn't include in this slide, and I didn't mention in this slide because basically IPR is a form that we can reproduce, that we can copy, that we can re-engineered. Anything that we can have re-engineered, uh, only that asset needs some kind of protection, because trade secret is a kind of IPR that doesn't be re-engineered. For example, if I take an example of Coca-Cola recipe, so this is a very well-known trade secret. So why it is not till date having don't have any patent, trade, any kind of thing, because this recipe till date no one, no lab has performed successfully with the re-engineering of that recipe. So all these 6 IPR needs to be protected when innovator knows that this can be copied, this can be re-engineered, reverse engineered. So now you can better understand why IPR. When anything that has been copied or that can be a chance of copying, we go for IPR filing. Every IPR have their own act. As I told you, Patent Act 1970, Trademarks Act 1999, Copyrights Act 1957, Design Act 2000, Geographical Indication, GI Act 199. So these are the act where you can check, you can study thoroughly what are the rules regulation for the filing of the requisite IPR. So again, in brief, 1957 copyright, 1970 patent, 1999 trademark, 2000 design, 201 PPV, Plant Varieties Act, 2016 National IPR Policy we have. And these are the administering bodies in the right of slide: DPIIT, CGP, Indian Patent Office, Copyright Office. So these are the bodies that take care, that examines, that laws the complaint. Eventually, on the higher side, High Court, Supreme Court are there. But at the administration level, these are the main authorities: Department of Promotion and Information Technology, DPIIT, CGP, Controller General, Patent, Design, Trademark, Indian Patent Office, Copyright Office. So in Indian patent system, we have total 4 IPR offices, and headquartered in Kolkata, with branches in Delhi, Mumbai, and Chennai. So these 4 offices work based on the jurisdiction of the applicant. If the applicant belongs any specific territory, so according to that territory, the office will be allocated and the case will be examined. Uh, Further procedure will take place basis on that jurisdiction. In this graph, you can just check that how year by year India has been improved their patent filing, copyright filing, design filing, and basically IPR filing. So we started with the financial year 18, then further increment in 19, 20, 21, 22. So these are the parameters that you can see. Uh, Last year, we have more than 1 lakh patent filed in Indian patent system. So starting with what is a patent? Basically, patent, when we have anything that is novel, inventive, and industrial applicable. If I am coming up with any concept that is novel, that is inventive, and that is having industrial applicability, when passed these 3 criteria, then you will have some exclusive right and you will get the patent granted, so that No other person can import, no other person can sell, can manufacture, can copy your invention without your prior permission. So basically, this is the definition. Now, the term of protection, every IPR, as I told you, we have 7 IPR and mentioned 6 IPR in my earlier slide. Every IPR is having some time, some certain period for term of protection. Beyond that period, you cannot expect the monopoly for that concept. Although that period is very much enough, after that period, it is of no chance that the technology will survive. It will be outdated somewhere. So for example, patent, this is 20 years time for protection. Means once you file a patent, let's say if you're filing a patent on 1st Jan 2026, then the maximum protection period for this patent is 20 years, 1st of January 2046. After that, although you have granted patent, although it is your invention, but after completing 20 years, you cannot claim that this is my work now. Still you need to pay, still you need to take license from me. So you cannot say like that beyond this period. Further, the important thing, it is not like the 20 years you are getting when you are paying the renewal fees, maintenance fees for the patent. Only in that condition you will get this term. If you are having only grant certificate but you are not maintaining your patent, you are not paying any renewal fees, then simply in that case it is not your intellectual property. You filed that patent, you grant that patent, but that is because you are not maintaining that patent, so it is not your intellectual property. So for every intellectual property you just need to maintain by paying the renewal fees, maintenance fees. Right conferred exclusive right to prevent others, as I told you, from making, using, selling, importing the patented invention without consent. Territorial nature, yes. IPR is a territorial right, means no invention you can say that is a global patent have. If you are having any person is saying, I will help you to grant a global patent, uh, this is totally false statement by that person, by that attorney. There is no global patent. Yes, there is a filing, PCT, Patent Cooperation Treaty, we can say, that is international filing. But the global patent, there is no. These are the territorial rights. If you are interested in a specific country, you have to move to that country. Then you have to go for all process that is requisite, that is mentioned in their own act. And then if the patent office of that country will have all things cleared, then only you have legal rights for your invention in that territory. Otherwise, there is no global patent, no global grant of single patent. As I told you that patentability depends on these 3 criteria: novelty, inventive step, industrial application. So one by one, I will discuss in detail what is novelty, what is inventive step, what is industrial application. Till here, if anyone have any doubt, please let me know. Now I am beginning with another part of this patent process, the criteria, 3 criteria. So till here, if anyone have any query, please let me know. So novelty basically depends on presence of your concept, public display of your invention, of your concept. If there is any publication, public display before your patent filing, then it is not known as novelty. If there is no display, there is no public disclosure before filing, then it will be purely novelty. There is a condition by Indian government, 1 year time period, a grace period is provided, but the disclosure made by himself, herself, by the inventor. For example, if I am filing a patent on 1st Jan 2026 for a technology, and by chance I published my paper before uh, one 1st of January 2026, but not after 1st of Jan 2025. Means the patent is okay for filing if you have just that one period, grace period, and that public disclosure by your self itself, not like any other person is having disclosed your technology and you are saying we have this grace period and I still want to file the patent. It is not possible. The grace period is okay only in that condition when the concept is disclosed by yourself, only in that case. So the invention, the concept must not be present anywhere in any form. So what is the anywhere in any form? Basically, anywhere means it is not like that if you are filing a patent in India and you have something, you are saying it is present in US, it is present in Europe, but I am filing patent in India, it is not present here. So it is not like that. The patent cannot be filed. The patent can be filed, but it eventually it will not the granted. Patent filing is not a very big thing, but the getting grant is a big thing. So filing a patent, publication of a patent is a very normal thing. Anyone can do. But once the positive examination have been done and you will get the grant, this is the big thing. Second criteria is inventive step. Inventive step is something that is very obvious. If anything, any concept that is very obvious for person that is ordinary skilled in that art. If you are presenting, if you are coming up with an idea that is very obvious for the person that is in that domain already, so it lacks inventive step. Your invention something like non-obvious in this sense, it is having some better synergistic effect. It is must have some efficacy. Simply, I'll say it have some validations data, validated data, some good example, working example, a good prototype, so that inventor can show it is not possible for person ordinary skilled in the art. So second criteria basically inventive step, and the third and the last criteria is industrial applicability. Actually, sometimes we have ideas that is in our mind, but eventually when start practicing on the machines in the lab, then it is not possible. That idea can be hypothetical in nature because we don't know what exactly will be the behavior of that component of that composition once we start trials. That's the reason for a chemical composition for pharma we have lot of clinical trial, because in that case we cannot take risk for human life. So this is the reason we need implementation and validation of the technology. If the implementation is possible, if the technology is validated, there is no such harm, then I will say it is industrially applicable. If anything that is not implementable, that is only in my mind. Sometimes it can be anything. Sometimes it can be a dream machine, it can be time machine, it can be XYZ. But if there are only concept in my mind, but I cannot have proper validation, I'll suggest don't go for filing until you have full blueprint, because it might be a chance in the end patent office can ask prototype of your concept. If the if the patent office feels you are mentioning the things that are hypothetical in nature. So I believe now all three concepts, novelty, inventive step, industrial application, is cleared to the audience. And once we will have any concept, first we will check these three criteria. Now going through in more detail for inventive step. Basically, novelty and industrial applicability is possible to achieve, easy to achieve. Novelty in the sense I have component A, B, C in one device. I have component D, E, F in another device, and I am coming up with the third device that is having all six components. We had sometimes before only mobile phones. After few years, we have camera in our mobile phones. So these are the implementations of technology, year by year growth in the technology. So novelty is not so tough to achieve. We can have combination of components, and then we have some unique output. But saying it is inventive, it is little bit tough. I am taking an example of a needle. There is a very good case law in this patent domain for our patent attorney, for our patent fraternity, because this case, although is very old, when the person filed the patent for needle, sewing machine needle, so it was rejected by US patent office. Again, the next authority, appellate authority, rejected this patent of sewing machine needle. The reason behind the patent before needle, that is the very basic needle, hand needle, that is having the hole on the upper section. That was the prior art citation for this patent. Every time office patent office were claiming that this is very obvious to make a hole in the lower section. When we have some needle that is having a hole in the upper section, it is very obvious to make the hole in the lower section. There is not a such big thing. Novelty is there. Yes, the hole is changed from top section to bottom section, but it is not having much inventive step. But eventually, US highest court, Supreme Court, give the grant to that patent because they admit, although the idea is very simple, very simple, that they are having hole in the lower section, but the technical effect is coming very wide and very important. So eventually, how the court evaluated that thing by evaluating the technical effects for that concept. So if you have some extraordinary technical effect, it doesn't matter your invention is easy or complicated. For patent, it is a myth. It should be complicated. It should be a big machine. It should be something that is very complex. There is nothing like that. Needle example is best for you, best for your understanding of inventive step. There is nothing simple like needle. So eventually, inventor attorney proved the inventive step because the technical effect was the very good, and the domain was not like a hand needle that was used in sewing machine. So on basis on these grounds, the inventor got the patent granted eventually after rejection from two authorities. So this is the story, very inspiring story and very good story to understand the concept of an inventive step and to understand how the simple thing also can be filed for a patent, but it should have some good technicality. Apart from that, these three criteria that I mentioned, novelty, inventive step, industrial applicability, we have a non-patentable section in India. This is mainly for Indian territory, not for other countries. In India, as we are developing nation, due to some reasons, due to stabilize our economy, to boost, to give boost our economy, we implemented this section 3 non-patentable section. So basically, after passing these three criteria, novelty, inventive step, industrial applicability, you also need to pass this fourth criteria. means your invention should not fall under these subsection that I have shown in my slide 3A, 3D, 3B, C, D, E, F, G, H, P. So your subject matter should not be fall under these subsection. For example, you cannot take patent for a natural law. If you are coming up with a natural law, for example, Newton's, Einstein's, so if they want to go for patent filing for their natural law, so you can check the history, they never filed patent because patent is not possible for the natural laws. Second thing, anything that is contrary to public order, morality, or harmful to health, it also not patentable. Mere discovery of scientific principle or any natural substance. Let's say, for example, if I'm discovering first time lemon, so it is not patentable subject matter. Patent is for invention, not for discoveries. So you cannot take patent for any something discovery of scientific principle or natural substances. Then the most contradictory section 3D and section 3 for pharma and life science people, basically new form of known substance without enhancement of efficacy, mere admixture, only aggregation of properties. I'm taking an example how you can understand this section 3D and 3. We have a very homemade shikanji kind of thing. So shikanji is a like where we have sugar, we have lemon, we have water, and we just simply mix and we just prepare it. When some company comes up like dew with some cold drink that is somewhere like same composition, sugar, carbonated water, something like this, but they will get the grant over the known prior art, that is the prior art shikanji, because they have enhancement in efficacy, better synergistic effect in that composition that they are coming up with. So to understand section 3D and section 3, you can take an example of homemade shikanji and like dew. Both have somewhere similar kind of work, similar kind of taste, not exactly similar, but the one thing is prepared on machine, on lab with validated data, and one thing is prepared in home very easily. So if you are coming up with any mixture, if you are coming up with any known substance, but the efficacy and synergistic effect must be good, like this example. Then section 3F, this is mainly for mechanical, electrical people, mere arrangement and rearrangement of known devices. Let's say I have a wire, I have a bulb. If I'm creating any arrangement of light, it is not patentable because both concept, both wire and bulb are available in market, and it is very obvious by combining we can have something a good light arrangement. So we cannot take because everyone have their own independent working. For countering 3F, there must be some single unit that should give output as a unity of the component embodied and incorporated in that system. So basically we have lot of component, but the output must be single and all component must not work independently. It should be some chain, it should be some unity in the device. Then only we can counter this mere arrangement and rearrangement. For example, if I am achieving something that is having mobile with camera, that is not a mere arrangement. First time if person coming up with mobile embodied in camera, that is not a mere arrangement. That is having some skill that he can do, that he can integrate that camera into the mobile. So mere arrangement is only when the all components are working independently. there is no input depend output of one component to another component. The input and output should be depend of one component to other component, and it should be integrated. Then only we can have, we cannot have, we can counter this Mayer arrangement, section 3F. Thus, next section, section 3H, methods of agriculture or horticulture. We cannot take patent for these methods. Further, we cannot take patent on treatment method, any treatment on human, any treatment on animal. If we are coming up with, we cannot take patent on that. Then we have no patent for plant and animal. If we are producing in lab, we cannot take patent on that as well. Then we have section 3K for mathematical equation, business methods, computer program per se, algorithms. We cannot take patent. If you have any new software, a new kind of website, for example, if Zomato, Swiggy, these companies will say, I want to register patent for these services, it is not possible. So you have some system that is having some unique hardware interaction for computer science IT people, then only it is possible to take patent on that. But a simple mere kind of website or any online tool, you cannot go for patent filing. Then section L, literary, dramatic, musical, artistic works. We cannot take patent for that. Copyright is the good IPR for covering these concepts, literary, dramatic, musical, artistic work. Then the last section 3P, traditional knowledge, duplication of known properties. We cannot also take a patent for the composition that is well known for achieving some output, for providing some better results for any problem. So traditional knowledge is also should not be there in your concept. It should be having some uniqueness with better efficacy and synergistic effect. So I believe the fourth parameter, I also explained what cannot be patentable. So these are the parameters, these are the subjects that is not patentable subject matter in India only. Because US can have the patent, few other developed country can also have patent on these subjects, but India doesn't provide the patent on these subject matter. So anyone? Yes, sir, please. Yes, sir, please. Yes, sir, please. Yes, sir. Which are having different items. Yes, sir. Yes, sir. Why few subsections are missing here, right? After A, instead of G is H, and after L, M N O P. Yes, sir. If ma'am, इसमें internet connection है? Sure, sure. No, 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 sir. Some are omitted, but that was not so much usable, so I omitted from my slide. But it is there. So I'll just show you if the system is having internet connection. So I'll just show you what are the sections. So basically, this is I'm opening the site of patent office in itself, ipindia.gov.in. So this is the Patent Act, whole Patent Act you can check online. And I'm just opening the section 3. So So this is the web page showing IP India websites. I am taking this excerpt from IP India itself. And as sir asked, very good query. So sir, it is showing G is omitted. And further we have M is mere scheme or rule method of performing mental act. Means if I'm coming up with any game, so I cannot take patent on that. A presentation of information. Sometimes any person is having a very good data, that is in lakhs, that is CR, but for that data, for that presentation of information, you cannot take patent. Then we have section O, topography. Topography, I believe you understand that we have PCB, printed circuit board. So on that we have some topography, how the components are connected and communicated from one component to another component. So that PCB, the golden lines we know on the PCB. So we cannot take patent for that. Although we have some separate act and separate IPR for this IC registration. So if anyone have novel IC, so not patent, but in that IPR can register that IC, that topography. But in patent, as all the 7 IPR different IPR, so in patent you cannot go for IC kind of topography kind of filing. So I believe, sir, you have now all the non-patentable subsections. So it was the very good question. So now we have already discussed the previous. M and O was not in my slide, but we also discussed these subsections. So these are the things that are not patentable subject matter. And important thing, simply I'll say, apart from promotions, apart from CV kind of thing, the main reason when patent IPR system was incorporated due to the commercialization. And commercialization is possible only for those things that are manufacturing at a single place, that are selling, that are having some single place kind of work. For example, if I am taking a patent, for example, it is not like कि अगर मैंने पेटेंट ले लिया तो मैं उसको पूरी तरह से एनफोर्स कर पाऊं. For example, I have a granted patent for an infrastructure like I am making smart city, I am putting CCTV, I am putting smart traffic lights, and I have further few other things. But when I start to implement these things, you can think it is not possible at single place. If it is not possible single place, how I will stop the other person from copying? I take a simple example. Let's say I have some good interior. It will be suit to your field as well. For example, I have some good. मेरे पास एक 15 by 36 very small space I have, and I am arranging all things, kitchen, balcony, all things, 2 3 rooms. So I achieved a very good idea, एंड दैट आई वांट कि यार ये बहुत छोटे रूम में मैंने कितना जबरदस्त नक्शा बनाया कि इसका मुझे पेटेंट लेना चाहिए ताकि कोई दूसरा वो कॉपी ना कर सके. आई एम सेइंग कि इसे कोई कॉपी ना कर सके. बट इंडिया जहां पे पॉपुलेशन 150 CR है, वी हैव बिलियंस ऑफ हाउसेस. जब उस फ्लोर को कोई उस एरिया में इंप्लीमेंट करना स्टार्ट करेगा, इज इट पॉसिबल आप उसे रोक पाएंगे? यू कैन नॉट स्टॉप. और ये कोई ऐसा पॉइंट ही नहीं है कि इसमें किसी को किसी कंपनी की कि भाई हमारे ये सेटअप है, आप इसे उठा के हमारे इस पे फ्लोर पे लगा दो. इवेंचुअली देयर विल बी सम कंस्ट्रक्शन लेबर, वो स्टार्ट करेगा, आप उसे बताएंगे, आप आइडिया देंगे, वो उसे बिल्ड करना स्टार्ट करेगा. बट अगर आपने इसका पेटेंट ले भी लिया और इसका किसी अटॉर्नी ने अपनी स्किल से पेटेंट ग्रांट करवा भी दिया, तो दैट्स व्हाई आई एम सेइंग कि अपार्ट फ्रॉम सीवी और अप्रेजल, जो एक्चुअल हमारा मकसद है कमर्शलाइज करना और कोई उसे इंपोर्ट ना करे, सेल ना करे, मैन्युफैक्चर ना करे, एग्जैक्टली मीनिंग ऑफ द पेटेंट इज कमर्शलाइजेशन, कि हम उससे एक अर्निंग कर सके. तो वो हम इस पेटेंट में कैसे कर पाएंगे? अगर आप बता सकते तो आप मुझे बताइए. बट इन माई सेंस इट इज नॉट पॉसिबल कि मैं उस चीज को पेटेंट होने के बाद भी रोक पाऊं. पेटेंट है, ग्रांटेड है, वैसे तो पेटेंटेबल सब्जेक्ट मैटर है ही नहीं, बट इन इंडिया, इंडिया पैसे ले दे के सब हो जाती है चीजें कहीं ना कहीं। तो अगर आपको चलो एक अच्छा अटॉर्नी मिल भी गया, उसने ग्रांट करवा भी दिया, तो आप इसको कॉपी होने से कैसे रोको? क्योंकि वो तो एक नक्शा है बेसिकली, वो हर कोई, आप किसको जाके कहाँ कहाँ तक नोटिस भेजोगे, किसके घर में एंट्री करोगे? तो बेसिकली इंफ्रास्ट्रक्चर, वी शुड नॉट गो फॉर पेटेंट फाइलिंग रेदर देन कॉपीराइट। हाँ, कॉपीराइट आप इसलिए करवाइए बिकॉज एनीथिंग दैट इज एक्सप्रेस्ड ऑन पेपर, उसका कॉपीराइट होना चाहिए। वंस यू हैव दिस प्लान, दिस गुड मैप, गुड आर्किटेक्चर, तो ऑब्वियसली अगर कोई बड़ी कंपनी अपना जब एक प्रोजेक्ट लॉन्च करती है तो उसमें वो शो करते हैं कि ये मेरा 2 BHK, मेरा 3 BHK है। ऑब्वियसली जब वो कस्टमर को अट्रैक्ट करना शुरू करती है, उसे वो बुकलेट देनी ही होती है, उसको वो हाइड कर ही नहीं सकती, कवर कर ही नहीं सकती। तो ऑब्वियसली वो फिर उसके प्रिंट निकलवाएगी। जब वो प्रिंट निकलवाएगी तो वहां पे आप उसे स्यू कर सकते हो कि सर इट इज अवेलेबल इन मार्केट, ये आपका कंपनी का नाम है, ये आपका पैम्पलेट है, यहाँ पे आपने बकायदा जो मैंने डिजाइन बनाया है, जिसका कॉपीराइट जिस आर्किटेक्चर का लिया है, वो मेरे नाम से रजिस्टर्ड है, आप उसको कैसे आपकी कंपनी यूज कर सकते हो। तो कॉपीराइट इज गुड वन इन दैट केस, बट पेटेंट इज नॉट गुड वन। एक एग्जांपल लेते हैं, फॉर एग्जांपल लाइक आई परचेज अ मोबाइल। when I purchased a mobile, I in that all IPR we have, wo I all IPR how we have, like the technology, mobile in itself। तो पेटेंट इज फॉर दैट टेक्नोलॉजी कि जो डिवाइस के अंदर जो चीज मुझे दिख नहीं रही, जब हम खराब हो जाता है उसे, जब हम जाते हैं उसमें जो आईसी होती है, कंपोनेंट्स होते हैं इलेक्ट्रॉनिक, तो उनके लिए उस कंपनी ने पेटेंट लिया है। जब हमने बॉक्स ओपन किया, उसमें हमें एक छोटी सी बुकलेट मिली, उसकी फंक्शनिंग बताती है, उसके XYZ पैरामीटर्स बताती है, उस चीज के लिए उस कंपनी ने कॉपीराइट लिया। कल को उसे कोई सेम कॉपी करना ना स्टार्ट कर दे कि हमने इतनी बड़ी डॉक्यूमेंटेशन तैयार की, उनका काम हमने मेहनत किया, हम हमारे लिए इजी होना चाहिए, हम यूज करेंगे अपने मॉडल्स में, बट नॉट अदर कंपनी। उसने उस बुकलेट का कॉपीराइट लिया। देन we have logo on that box, on that device. If I'm purchasing Apple, Apple kind of logo is there, so that is trademark। the fourth IPR design, हर मोबाइल का एक अपना एस्थेटिक है, अपना एक एक्सटर्नल अपीयरेंस है, जिसको देख के यूजर अट्रैक्ट होता है कि यार ये मोबाइल अच्छा है, ये मोबाइल मुझे अच्छा लगा, इसका कैमरा ऐसा अच्छा लगा, इसकी XYZ प्लेसमेंट मुझे अच्छी लगी। तो जब ऐसा कुछ होता है, कोई एक अच्छा यूनिक आइकॉन, शायद आपने सुना हो, 12-15 साल पहले एक पुराना केस था, एप्पल का सैमसंग ने मैसेज का डिजाइन कॉपी किया था, 1500 CR का उसमें उसे कंपनसेशन देना पड़ा था। तो 10-12 साल पुराना ये सूट है। तो उसमें उसने सिर्फ उनका आइकन को एक टाइम 10-12 साल पहले की बात है कि सेम आ गया था सैमसंग और एप्पल का, तो वहां पे उन्होंने इन्फ्रिंजमेंट फाइल किया, उनको दे गेट 1500 CR, यूज दैट आइकन डिजाइन। तो दैट्स आई एम सेइंग कि अब उस बॉक्स से आप आइडिया ले सकते हैं, दे दैट बॉक्स कवरिंग 4 IPR, डिजाइन कवर किया उस मोबाइल के एस्थेटिक ने, ट्रेडमार्क कवर किया उसके लोगों ने, कॉपीराइट कवर किया उसकी बुकलेट ने, पेटेंट ने उसकी टेक्नोलॉजी। सो आई बिलीव इट विल बी इजी टू अंडरस्टैंड व्हाट एग्जैक्टली IPR is requisite, is necessary for my work। So because आप without knowledge, if you are going to attorney, definitely attorney will suggest you 2-3 more, because eventually attorney will get the money। So if you have better understanding किस चीज का क्या लेना चाहिए, क्या नहीं लेना चाहिए, so you can simply will put your suggestion, you will say कि I just want to file patent, I just want to file copyright or this and this। So basic understanding must be there before filing of IPR, so that attorney or other person cannot make fool to you। So every IPR have their own significance, it is not like that कि ये नहीं तो इसे कर लेते हैं, इसे नहीं तो इसे कर लेते हैं। By this box you can understand every IPR have their own significance। अगर मैंने सिंपली वो जो टेक्नोलॉजी है उसका पेटेंट ना करवा के, यार वो महंगा है, उसमें काफी ज्यादा खर्चा है, उसको कॉपीराइट करवा लेता हूँ, तो कॉपीराइट इज फॉर सेलिंग द प्रिंटेड कॉपी, नॉट दैट आर्टिकल। तो आपका वो ऑल्दो कॉपीराइट हो जाएगा, ग्रांट भी हो जाएगा, बट द पर्सन कैन इजीली स्टार्ट मैन्युफैक्चरिंग एंड सेलिंग। तो it is better to have understanding which IPR exactly you need and then only go for that IPR file. So coming back to my slides. Shared. So as I already told you, in Indian patent system, we have total 5 patent offices, head offices in Kolkata. अभी ये बढ़ भी गए हैं. We have office also in Ahmedabad. Ahmedabad में भी है. And I believe once office is opened in Hyderabad also. I'm not sure, but these 4 office and we also have one office is in Ahmedabad. Types of patent application. Yes, patent basically having stages, having types of applications. So provisional application, sometimes we have any idea that needs to be protected, but at the same time, because of clinical trial and public trial purpose, we need to disseminate that technology in the public. तो एज आई टोल्ड यू कि अगर हमने उसे पब्लिश कर दिया, डिस्प्ले कर दिया, वी आर हैविंग कॉपीड बाय अदर. So to stop this, so that no other person can copy it, and at the same time I need some public disclosure due to trial reasons, public trial, clinical trial. So this provisional filings concept came. In this provisional filing, you will file your patent with the present data and you have 1 year timeline. In that 1 year, you have to complete your patent. And once you will have complete data within that 1 year timeline, you just file your complete and final specification, that is complete specification. So provisional specification basically used by life science and pharma people uh, generally. Although anyone can file, but maximum filing, provisional filing done from these domains because they have clinical trials, they have opening of their documentation, so many places, but at the same time, they have to taken care of the protection of IPR. So this provisional filing better in these cases. PCT national phase, basically this is a gateway for entering in other countries. Actually, patent IPR is very important when we have deadlines question, because every step having some deadline. For example, as I told you, once we file provisional, then we have 12 months timeline for complete filing. Once we file any patent, then we have again 12 months for PCT filing. Means if I want to file my patent outside India in different countries, then within 12 months I have to decide further. If I have more than 3, 4, 5 countries, then we choose this PCT route. Why? Because in 12 months it is easy to achieve 4 5 maximum countries. But if you are planning more than 5 countries, then first you need to file PCT. Once you will file the PCT application, then you have increased timeline of 31 months. Means if I am filing any patent on 1st Jan 2026, then after 1st Jan 2026 till completion of 31 months, you can have time to select other countries. So you can just file PCT if you are planning filing outside the Indian territory and you are planning more than 3, 4 countries. In that case only, I prefer PCT filing. Convention is direct filing. As I told you, if I am planning only 3, 4 countries, then there is no need to file PCT. You just simply file in India and then you will file in another country in which you are interested, but again within the timeline that is 12 months. Further, divisional application, patent of additional, these are the another category of patent filing. Divisional application, simply I'll say, let's say I am filing a patent for pen with camera. Patent office examined that application and found that this is not a single patent. You should go for 2 patents, one for camera, one for pen, a writing article. So if we file these 2 application, it will become divisional application. as this word in itself describing the case. Divisional means I am just simply dividing my application in two or more than two patent, and we have one main patent that will be the parent application, means the pen with camera will be the parent application, and once the examined and patent office uh, instructed to divide our application, it becomes divisional application. So this is the concept of divisional application. Patent of addition, इसी एग्जांपल को मैं कंटिन्यू करता हूँ. लेट्स से आई फाइल्ड अ पेटेंट फॉर राइटिंग आर्टिकल, बट later after a few months I thought there must be some camera in the pen, then it will be patent of addition. The difference between divisional and patent of addition is filed by me itself, कि मुझे लगा इसमें मैंने मॉडिफिकेशन किया, मुझे इसके लिए एक और पेटेंट डालना चाहिए, तो आई विल जस्ट रेफर माय पेरेंट एप्लीकेशन taking priority of that patent and will file another next application. Divisional application is instructed by patent office and for already filed patent. So yes, yes, exactly. Every patent is having somewhere addition. Although we have concept of this patent of addition, but less than 1% cases use this patent of addition, because it is very obvious that every time we have modification and improvement in our technology. Sometimes we have mobile, then we have next stage. So I will not say कि इसका मुझे patent of addition फाइल करना है. I will file a fresh patent with that mobile phone having a camera. Although वहां पे patent of addition भी कर सकते हैं, but 99% people file fresh patent. 1% because these things will be very detailed, काफी expertise होना चाहिए कि किस condition में, because fees and everything you have to pay separately. It is not like that कि आपने एक पेटेंट फाइल कर दिया, उसी पेरेंट एप्लीकेशन में वो एडजस्टमेंट हो जाए. नो, उसका सेपरेट ड्राफ्ट बनेगा, मीन्स वो टोटली एप्लीकेशन डिफरेंट होगी, न्यू होगी, बट उसको सिर्फ प्रायोरिटी मिल जाएगी आपकी प्रीवियस एप्लीकेशन की, पेरेंट एप्लीकेशन की. तो जहां आपको लगता है कि यस ये डिस्क्लोज्ड हो चुका होगा मैटर उस टाइम ड्यूरेशन के बीच में, लेट से मैंने आज एक जनवरी 2026 को राइटिंग आर्टिकल पेन का पेटेंट फाइल किया, फिर मुझे आइडिया आया कैमरे का 6 महीने बाद. अगर मुझे ये डर है कि उस 6 महीने की ड्यूरेशन में किसी ने फाइल किया होगा, और उसने फाइल किया होगा, तो अगर मैंने 1 जून 2026 को फाइल किया तो उसका वो पेटेंट मेरे पेटेंट को किल कर देगा, एंटिसिपेट कर देगा. तो इन दैट कंडीशन मैं आई चूज पेटेंट ऑफ एडिशन, क्योंकि वहां पे मेरे को वो डेट 1 जनवरी की मिल जाएगी. तो ये हमें एवेल्युएट करना आना चाहिए, देन वी कैन गो फॉर पेटेंट ऑफ एडिशन. अदरवाइज इवन आई विल प्रेफर कि सेपरेट एप्लीकेशन फाइल कर दी जाए, क्योंकि जो आपने कहा वो बहुत अच्छी बात है कि every time we have modification, every time everything is improvement. तो अगर मैं इस तरह से देखूंगा तो हर चीज पेटेंट ऑफ एडिशन ही है, एक ही पेटेंट की ब्रांच निकलती चली जाएंगी. वी कैन नॉट डू लाइक दैट. पेटेंट फाइलिंग प्रोसेस. So this is the total life cycle of a patent. Total we have 7 stages in this life cycle, and firstly, we start with patentability search. Once we have any concept, we start with patentability search. We check that what is the scope of that invention, and these are few databases in past patent scope, SpaceNet. These are the databases that is having patent literatures. Although in patentability search, it is good not only search for patent, because patent includes all things, non-patent literature, patent literature, videos, even sometimes audios, pamphlet, brochure as well. So yes.
Funding process, publication has like almost for 9 to 18 months. So in between, अगर same idea कोई और publish कर देता है.
No. Once I file the patent, the moment, अभी जो मैंने पेटेंट ऑफ एडिशन की ही बात की, मैंने आपको बताया ना कि हमारा जो प्रायोरिटी डेट है वो मैटर करता है. उसके बाद पेटेंट कितने साल में ग्रांट हुआ, पेटेंट कितने महीने में पब्लिश हुआ, उसका एग्जामिनेशन. No. If I'm filing a patent on 1st Jan 2026, उसका पब्लिकेशन जब मर्जी हो, उसका पब्लिकेशन चाहे 2 साल बाद हो, चाहे 10 महीने बाद हो, whenever it will be published और whenever it will be granted. पेटेंट 1 साल में भी ग्रांट हो जाता है, पेटेंट 10 साल में भी ग्रांट होता है, पेटेंट मिनिमम टाइम पीरियड 6 महीने का रखा जाता है, 6 महीने से पहले नहीं ग्रांट हो सकता, पब्लिक इंस्पेक्शन के लिए छोड़ा जाता है, तो उसके बाद 7 मंथ्स में भी ग्रांट हो सकता है. तो इट इज नॉट लाइक कि जो पेटेंट 7 महीने में ग्रांट हुआ उसकी वैल्यू ज्यादा थी, जो 10 साल में ग्रांट हुआ उसकी वैल्यू कम थी. इट इज नॉट लाइक दैट. टाइम प्रोसेसिंग अलग अलग हो सकता है, बट आपकी प्रोटेक्शन स्टार्ट हो जाती है द मोमेंट यू फाइल दैट पेटेंट. तो यू डोंट नीड टू वरी अबाउट दैट थिंग कि मेरा एग्जामिनेशन लेट हुआ, पब्लिकेशन लेट हुआ, उस बीच अगर किसी ने फाइल कर दिया, बिकॉज एवरी पेटेंट हैव द मोस्ट इंपॉर्टेंट थिंग, फाइलिंग डेट, दैट मैटर्स. जो हम सर्च करते हैं, जो अभी मैंने अपने स्टेज 1 पे मेंशन किया हुआ है, इन्वेंशन डिस्क्लोजर एंड प्रायर आर्ट सर्च, इस सर्च में बेसिकली हम यही चीज चेक करते हैं कि हम जो भी डाटा पिक करते हैं वो अपनी फाइलिंग डेट से पहले का चेक करते हैं. वी डोंट केयर कि हमारे बाद क्या हुआ, हमें बस ये देखना है कि 1 जनवरी 2026 से पहले वो चीज किसी भी फॉर्म में, यूट्यूब पे, फ्लिपकार्ट पे, अमेजोन पे, किसी भी पैम्पलेट में, किसी भी ब्रोशर में, किसी भी तरह से, जो मैंने आपसे कहा था, एनीवेयर इन एनी फॉर्म. एनीवेयर मीन्स दुनिया के किसी भी कोने में, इन एनी फॉर्म मीन्स किसी भी तरह से वो पब्लिश नहीं होनी चाहिए. अगर everything is positive, then we start drafting of the patent specification. Drafting of patent specification means drafting claims, description, drawings, abstracts. You can do yourself as well, but generally preferable to hire an attorney, because every section have their own sanctity, having their own rules and regulation, and you as an inventor expertise in your domain, and this is a very unique domain in itself, patent IPR. So the attorney will better know how to draft these things. After completing the draft, you have few forms, bundled of forms, form 1, 2, 3, 5. Every form have their own significance. You just need to submit all these forms with patent office. So once this process, after completing the stage 3, you will get patent application number, and this will be your reference for your concept. Every time whenever you will say for your patent, you need that application number. So once you will submit the document, there are two routes in India for publication. One route, you will get the publication within 30 days. Another route, if you are not choosing expedited publication, automatically it will be published after 18 months automatically. But if you want to choose early publication, if you want early publication, then you need to pay some extra fees, 2500 for natural person, for startup, for academics. If you pay 2500 extra in the form of form 9, if you submit this form 9 and you pay 2500 extra, then you will get the early publication within a month. So another thing, request for examination stage 5. Actually, sometimes applicant authors think that patent will be examined automatically. It is not like that. You have to apply examination, then only patent office will look into that. And if your patent is examined and granted, then only you have legal right. It is not like that कि आपने patent file कर दिया, you are filing patent and you are saying it is my product and I have my legal right over that product. It is not like that. Until आपका patent grant नहीं है, जब तक आप किसी को नहीं रोक सकते, आप सिर्फ उसे मेंशन कर सकते हैं, नोटिस दे सकते हैं कि I have filed a patent, so taken care for that as well. But you cannot stop until you have grant certificate. You cannot force to stop any person. So once the patent examined at stage 3, you will have examination report, you will start prosecution, you will counter the cited document, you will tell the patent office how the document, cited document is different from your invention, and then you will get the patent if still patent office is not satisfied, then the last stage is hearing. It will have face-to-face hearing with a controller who is handling your case, and you have to convince through your arguments. If you will able, then you will get the grant, and otherwise it will be rejected. So these are the 7 stages. Once start with patentability, sir, then start with drafting, then start with filing, then publication, then RFE, request for examination. Then after receiving the examination report, it will be response filing, hearing, and eventually grant. So there will be two publication in a life of a patent. One publication when you will file a patent. As I told you, the patent filing doesn't give you patent right fully. So that's why these are two separate publications. Once the patent is granted, then patent office and you can show to the public, to the society that now the patent has been granted. Now, if you are doing anything, stop that selling, manufacturing, or any, importing anything. Otherwise, the person I will sue you because I have eventually the granted patent. This is in another form, like we started filing. Then, as I told you, we have, if any provisional application within 12 months, we need to submit our final application, that is known as complete specification. Then if I'm not filing Form 9 expedited early publication, then automatically it will be it will be published after 18 months. After that, RFE फाइलिंग इज ऑल्सो हैविंग सम डेडलाइन. इट इज नॉट लाइक दैट कि मैंने 1 जून 2026 को पेटेंट फाइल किया है तो मेरा जब मन करे मैं उसकी एग्जामिनेशन फाइल करूं. देयर आर स्पेसिफिक टाइमलाइंस एंड दिस टाइमलाइन इज लाइक 31 months for RFE file. If I am filing any patent on 1st Jan 2026, then within 31 months I have to file this RFE. Otherwise, I will lose my right. I have no right over that patent. So anyone can use it, anyone can do anything for that technology. Once we will receive the examination report, then we have response submission within 6 months. Means once the examination report is generated, within 6 months we have to file response. ये भी ऐसे नहीं है कि एग्जामिनेशन रिपोर्ट आ गई उसके बाद हम हमारा मन कर रहा है जब जब मर्जी है उसका आंसर करें. इट इज नॉट लाइक दैट. If examination report is generated 1st Jan 2026, 30 June 2026 will be the last date to submit. Otherwise, again, you will lose your right. So these are the timeline basically. Although 40 to 60 plus, these are not hardcore time. It can be extended because the processing of patent totally depend on the pendency in the patent office. If there are more patent, definitely it will take your time. And if there are less patent, you will get early. These are the fees, filing fees, early publication fees. As I told you, 2,500. Actually, these are the physical submission fees. When you are submitting your document online, you will get 10% discount for these mentioned amount. If you are filing online, it will be the 1,600. If you are filing online, it will be 2,500. If you are filing online, request for examination, it will be 4,000. So expedited examination. Yes, one concept I like to discuss here, that as I told you, we have two options: early publication and normal publication. In normal publication, it will be published after 18 months. In early publication, it will be published within a month. So same like examination, we have two routes, two options. One option is normal examination. In normal examination, it will take generally 2 years at least. Generally 2 years it will take for examination. But if you are filing expedited examination, Form 18A, in that case, you will get your examination report within 6 months. So your process will become fast and you will get the examination report within 6 months. But for that, you have to be in some specific category, because not all all legal entities cannot apply for expedited examination. For filing expedited examination, either you have any startup, either you have any female applicant, either you have any name of government organization, either you have any international filing or government funded project. So if you are falling under these categories, startup, female inventor, international filing, or government organization, government funded, then only you can file for Form 18A. Then you can get the examination. You can get the early examination report. Otherwise, it will take time, 2 years. Then renewal is every month. It depends on the year. As I told you, it is not like that once you will file the patent, you granted the patent, you have right again. You can take example of your life insurance or any policy. It is active until you are paying premium for that policy. If you are not paying premium, your life is not insured for under that premium, under that policy. So same like patent, if you are paying that renewal maintenance fee to the patent office, only in that case patent office will taken care and your application is active. Otherwise it will become abandoned and you have no legal right. Now I am coming to the most important part, research translation. Commercialization, the most important thing for a patent, because generally in today's time we have like if I say 100 patent has been filed, only 2 or 3 patent, maximum 3 patent is commercialized. 96, 95 patents are just silent. Even for big company, if you will check the data, only 2 or 3% maximum patents are working and commercialized. This data is I'm saying for Google, Apple. It is not like even Google and Apple, Microsoft, if they are filing patent, they are commercializing each and every patent. It is not like that. Sometimes we just file due to reasons, but commercialization is not the purpose. So research translation basically providing TRL to your invention, to your concept, and TRL means technological readiness level. TRL 1, 2, TRL 3, 4, TRL 5, 6, 7. So basically, as I told you, when I took the example of map, bachelor architecture map, floor mapping kind of thing. So as I told you, it is not necessarily if my patent is granted, it is 100% implementable. It is not necessary. So if patent is granted, but it is having very basics thing, it is not implemented yet fully, then it will come under TRL 1 and 2, because it is very basic research. It is having very basic idea. It doesn't have any prototype. It doesn't have any further proof of concept, any validated data, any working example. If I am having a patent granted, but don't have any prototype, but have the proof of concept, data is validated, but the actual product is not prepared yet. So in that case, we will just simply have TRL 3 to 4. If we have prototype and we have working model, then we can have a TRL 5 to 6. Further, if the technology is implemented at the field, we have also field validation. Then we have TRL 7. And further, we have if commercialization, we have commercialized our product, our granted patent, then we can expect TRL 8. And if our product is in the market, users are using that product, then we can have uh, TRL 9. So basically in research translation, we just need to evaluate TRL and we need to achieve next TRL on whatever TRL we have currently. So these are few organizations that helps in TRL that you will contact. Some are government organizations, some are private organizations. IIT also help in TRL. So in next slide, I am just coming up with the India's technology transfer ecosystem in itself, like common mode of transfer, exclusive rights, assignment of patent rights, sponsored spin-off, and key Indian players where these things you can take help like NRDC, BIREC, DSIR, AIM, Niti Aayog, TIFAC, IIT, IISc, ICR. So these are the organizations that help you once you have any concept, any idea that will help you through funding, that will help you through their labs, that will help you to search companies. So you can contact these organizations and you can also have sometimes fund as well from these organizations for better improvement of your technology. So licensing model, licensing are exclusive, non-exclusive, cross-licensing, compulsory, exclusive, basically only single licensing will be there, non-exclusive, multiple other parties can be there, cross-licensing, two parties will exchange the right, I will give you something, you will give me something, compulsory licenses basically you have to give to the government. It is nothing to do with any private entity. Compulsory license is only for Indian government and only for extraordinary circumstances. So government schemes, these are government schemes that supports IPR, few schemes for trainings in IPR, few schemes for giving funds to the concept for further improvement and further manufacturing. Few schemes are to start your idea with basic. So depends on the stage and the knowledge. You just take advantage of the requisite scheme that is NIPAM, SIPP, SIP, EIT, NRDC, LSP, TTV. So these are the schemes basically, government schemes that supports innovators to help and to motivate young and inventors, and you can have better ecosystem and better increase in IPR filing. So best practices for researchers in IP. Before disclosing your idea, first file requisite IP. I am not saying for only for patent, for any IPR, I will suggest before disclosing your idea, first go for IPR filing, then maintain data proper because deadlines are very important. If you miss any deadline, you will not have any right over your technology, over your IPR. So better to maintain a notebook and all deadlines. Conduct thoroughly prior search, need to prepare a landscape, and then you have to some disclosure through your institute, your IPR cell, your through your organization. So you have these things that you should prepare well before filing IPR and before disclosing your idea in the public domain. So I'll suggest don't go for any disclosure in public domain if it is having a very good idea and very good concept. First go for IPR filing, then go for any kind of paper publication. So thank you so much. Further, if you have any query, any doubt, you may please let me know. And you may also have like my mobile number that I presented in my first slide. So here it is 9958310827. So anytime you have any query, you may also ask, you may also WhatsApp message. Uh, I'll try to answer your query. So thank you so much for listening me. For your any query, you just let me know, please.
Thank you so much, sir. As we conclude our first informative and engaging session of the day, I would like to sincerely thank our speaker, Dr. Harish Sharma, for providing such valuable insights into IPR and innovation in the field of architecture and design research. The floor is, of course, now open for questions and key discussions from all the participants who have joined offline and online. It is requested for participants who have joined online to unmute themselves, switch on their microphones and speak, or may even write in the chat box. Do we have any questions?
So my concern is like we have already put the copyright certificate over there, right, to the code. So can we for patent or copyright again that particular thing faces or some stages of that reports into our
Yes. Actually, as I told you, when I take the example of mobile phone, every idea is having their own significance. So firstly, you just create the significance. What exactly about the idea? Is go for copyright. But as I told you, there are two component technology, like mobile and the technology to copyright. So the person cannot the person cannot stop other company from manufacturing that mobile because उसने उसका copyright लिया है. So firstly we just need to evaluate the significance कि उसमें exactly हमें चाहिए क्या. So जहाँ पे copyright की जरूरत है, let's say if I am coming up with a poem, obviously उसका copyright ही बनता है कि उसको कोई दूसरा circulate ना करे, कोई उसे अपनी कविता ना बताए और उसे books में ऐसे एग्जैक्टली जो टेक्नोलॉजी है वो पेटेंट में जाएगी, जो एक इम्प्रेशन है पेपर्स का वो कॉपीराइट में जाएगा. यस सर. यस यस यस. सी नोवेल्टी सबसे पहला क्राइटेरिया है हर आईपीआर का. अगर आपने कॉपीराइट फाइल कर दिया है एक आईपीआर का तो ऑब्वियसली उसकी नोवेल्टी ब्रेक हो गई. बट अगर वो आप ही का आईपीआर है, आप ही ने उसका कॉपीराइट फाइल किया, लेकिन जो मैंने आपको स्टार्टिंग में बताया था 1 साल का ग्रेस पीरियड होता है, उसे आप हमेशा याद रखिएगा कि अगर बाई चांस, क्योंकि नो वन नोज जब तक कोई उसे अवेयर ना करे, अगर किसी ने गलती से उसे डिस्क्लोज कर दिया है बट विद इन दैट टाइम लाइन ही कैन स्टिल फाइल पेटेंट. तो अगर वो टाइमलाइन है और वो पेटेंट का सिग्निफिकेंस है तो आप कर सकते हैं. अदरवाइज सिंपली आप सबसे पहले कोई भी आईपीआर फाइल करने से पहले अगर आपके माइंड में एक छोटा सा भी आइडिया है, सिंपली मैं एक लाइन मेरी आप याद रखिए, अगर आपके माइंड में छोटा सा भी आइडिया, सबसे पहले वो आपको किसी को बताना नहीं है, कहीं पे भी किसी भी फॉर्म में डिस्क्लोज नहीं करना, बिकॉज यू डोंट नो इन दैट कंडीशन कि उसकी क्या वर्थ है. नो नो, आफ्टर फाइलिंग ही कर सकते हैं. After filing, you are protected because you have application number, data with the patent office. Then you can disclose display. But before filing किसी को बताना नहीं है. और अगर आपने गलती से डिस्क्लोज कर भी दिया है तो आपके पास वो 1 साल का टाइम पीरियड है. और कॉपीराइट की मैं आपको एक स्पेशलिटी बता दूं कि कॉपीराइट रजिस्ट्रेशन ऑटोमेटिकली, अगर मैं कोई चीज लिखता हूं लेकिन मेरे पास एविडेंस है कि वो मेरी ही है तो वो ऑटोमेटिकली रजिस्टर्ड होता है. यू डोंट नीड टू पे एनी गवर्नमेंट फीस. हम कॉपीराइट करवाते हैं बट फॉर कॉम्पैक्ट and for making strong our right, legal right. Otherwise when you will google it, just आप इतना लिखेगा is copyright get automatically, तो you will get more thorough details. अभी सेशन में डिटेल में नहीं, बट कॉपीराइट की एक सबसे बड़ी इंपॉर्टेंट ये है कि इट विल ऑटोमेटिकली रजिस्टर द मोमेंट आपने उसे क्रिएट किया, बट आपके पास एविडेंस होना चाहिए कि ये मैंने ही क्रिएट किया था. इसके बहुत सारे केस लॉ भी हैं कि एक बिकॉज आई एम नॉट अ फेमस पर्सन, अगर मैंने एक पेंटिंग बनाई और एट द सेम टाइम इफ आई नी फेमस पर्सन वो मेरी कॉपी करके, तो वो यही माना जाएगा उसने करी है. मैं उसे काउंटर ही नहीं कर पाऊंगा. मैं उसे काउंटर ही नहीं कर पाऊंगा क्योंकि नो वन नोज मी. वो मुझे कौन सुनेगा. तो इन दैट कंडीशन मैं पहले कॉपीराइट लूंगा. लेकिन अगर वही सिनेरियो उस बड़े पेंटर के साथ होगा तो वो बेशक कॉपीराइट नहीं भी कराए, उसने बना के एग्जीबिशन लगा दी, उसका एविडेंस है कि ये मेरा ही था. समझ रहे हैं.
Thank you so much, sir. I would like to take this opportunity to
Excuse me.
summarize. Oh, we have one
Yeah.
more question. Sorry.
This is just in continuation to the question asked by ma'am. Ma'am started with her question with the PhD thesis report. So in our university, like any other university, there is a provision of copyright transfer. When a scholar completes the PhD, copyright transfer form is filled, right? So, and most probably, I'm not very sure, but the thesis report becomes the property of the university after the copyright transfer. Right. So how much is the option remaining for the scholar after this copyright transfer?
ओके, बहुत अच्छा क्वेश्चन पूछा आपने। एक्चुअली यहाँ पे एक चीज मैं आपको ये भी बताना चाहूंगा कि आईपीआर कॉपीराइट एंड डिजाइन, दीज टू आर अ वेरी वीक फॉर्म ऑफ आईपीआर. व्हाई आई एम सेइंग वेरी वीक फॉर्म? if I am taking an example, I am taking an copyright for my name is Harish Sharma. I am taking copyright for this. My name is Harish Sharma. I can take second copyright for I am Harish Sharma. Means if I am taking a code, अगर मैंने किसी कोड के लिए कॉपीराइट रजिस्ट्रेशन किया in C++ or in Java, and that same logic I am implemented in Perl or Python, तो मैं उसके लिए कॉपीराइट ले सकता हूँ. Means through minor changes I can do it again, even through very minor changes, because in journals and in university, in employer and employee have some agreements. जब मैं यहाँ पे जॉब के लिए आया था तो मैंने एक एग्रीमेंट पे साइन किया कि जो भी आईपीआर जनरेटेड होगा मैं अपनी खुशी से वो एमईटी के नाम पे. बट एट द सेम टाइम मुझे लगता है कि वो मुझे कुछ करना है, अब मैं यहाँ से निकल चुका हूँ, तो इस लॉ को ध्यान में रख के आप अपना कर सकते हैं. हिंट मैंने तो वेरी माइनर चेंजेस. डिजाइन में भी सेम यही है कि लेट्स से आपने एक कंपनी ने डिजाइन रजिस्टर करवाया शार्प एजेस के लिए अपने मोबाइल फोन का. ये मेरे पास एक मोबाइल है, शार्प एजेस के लिए मैंने इसका डिजाइन रजिस्टर करवाया. बट कॉम्पिटिटर ने देखा कि इसका शार्प एजेस का तो डिजाइन रजिस्टर हो चुका है. द कॉम्पिटिटर इज सीइंग दैट द कंपनी इज हैविंग ऑलरेडी design registration for sharp edges. Now what he will do, he will just make a minor modification, U-shaped edges, not sharp edges. So that will be different design. So through minor changes, you will get 100% easily grant. But in patent, why everyone is running behind the patent? We have a law of prima facie, doctrine of equivalence. Why of these law? In patent, it is not possible. पेटेंट में अगर किसी ने माइनर सा चेंज किया, थोड़ा ज्यादा भी चेंज किया है, बिकॉज ऑफ दीज लॉ स्टिल ही इज इन्फ्रिंजिंग. बट इन कॉपीराइट अगर उसने माइनर सा भी चेंज कर दिया, माई नेम इज हरीश शर्मा, आई एम हरीश शर्मा, शार्प एजेस से यू कर्व्ड एजेस कर दी उसने, तो भी वो उसका नहीं माना जाएगा, दूसरे का माना जाएगा.
I think just because of this reason, especially in the daily use commodities, we have similar kind of objects, but all of them are having their different copyrights, like writing pens.
Exactly.
Or even the toothbrush.
Exactly.
Most of the companies are making same thing for the same function.
Exactly.
But there is a minute difference of design.
Exactly. Honestly, अगर मैं आपसे कहूँ, copyright registration is not a very big thing. Honestly, अगर मैं कहूँ, पेटेंट लेना बहुत बड़ी बात है. कॉपीराइट मैंने आज तक अपने 12 साल के करियर में किसी को देखा ही नहीं है उसका कॉपीराइट रिजेक्ट कहीं हुआ.
Do we have prior art search in copyright also?
As I told you, if I know कि ये मैंने ही बनाया है तो ऐसा हो ही नहीं सकता कि, क्योंकि अगर if even is MR is different. Okay, you are getting.
Because
So I will
in patent we usually compare it with the similar cases existing.
पेटेंट में is a patentability
Through
search.
prior art search.
Exactly. But कॉपीराइट में देखिए, अगर मुझे कॉपी करना भी है, कि मुझे 4th क्लास से ही पता था कि अगर मुझे कॉपी करना भी है तो मैं थोड़ा सा चेंज कर लेता हूँ ताकि उसे ना पता चले. दैट इज अ वेरी कॉमन सेंस. तो इसलिए वहां पे सर्च नहीं करेंगे. अगर मैं किसी का कॉपी भी कर रहा हूँ तो मैं उसको क्विल बॉट है आई गेस, उस पर रिफ्रेश करवा दूंगा और मैं उसका फाइल कर दूंगा. आई विल गेट दैट.
Right. So there are loopholes.
नॉट लूप होल्स, नॉट लूप होल्स. अगर आप इसकी सैंक्टिटी पे जाएंगे ना,
We can call it flexibility then.
क्योंकि देखिए अब हमारे टाइम में प्रदीप एबीसी चलते थे इन फॉर फिजिक्स केमिस्ट्री. आई डोंट नो अभी क्या है स्टेटस. तो जब नई सड़क पे मैं जाता था तो वहां पे धड़ल्ले से उनकी कॉपी वो बिकती हैं, शायद आपको भी आइडिया हो. आपके पास खुद बंदा आएगा, क्या चाहिए आपको. तो क्या आपको लगता है उन कंपनियों को नहीं पता होगा? वो तो जबकि एग्जैक्टली कॉपी बेच रहे हैं उसकी, एग्जैक्टली.
Even जो ये रोड क्रॉसिंग्स पे नॉवेल्स मिलते हैं,
तो इसी वजह से मैंने आपसे कहा कि देखिए यहाँ पे थोड़ा सा आपको डेप्थ में स्टडी करना पड़ेगा, और स्टडी भी कुछ नहीं, बस लॉजिक्स देखिए। लॉजिक्स ये है कि सारा खेल यहाँ पे अर्निंग का है। आपको एक बहुत अच्छा, बहुत प्यारा एग्जांपल दूंगा कि एक हम हाईवेज पे जाते हैं, ठेला लगा होता है, उस पे कोई जूस बेच रहा है, कोई बिरयानी बेच रहा है, कोई कुछ बेच रहा है, उसने किसी एक्टर एक्ट्रेस का फोटो भी लगा दिया, ठीक है। वो एक्स वाई जेड एक्टर एक्ट्रेस, हीरो हीरोइन का फोटो कि भाई ये वो जूस पी रहा है या वो बिरयानी खा रहा है। क्या वो बड़ी कंपनी कर सकती है? क्या वो अपने पैकेट पे पोस्टर लगा सकती है? क्यों? क्योंकि वो मैंने अभी आपको जो बताया था, पॉइंट ऑफ सेल उसका पता है शाहरुख खान को, सलमान खान को, वो तुरंत वहीं पे नोटिस भिजवाएगा कि इसने मेरे पोस्टर कैसे लगा दिया। तो इट इज ऑल अबाउट मनी। इट इज बॉटम लाइन, सब पे मनी है, किसी को कोई मतलब नहीं है आप कुछ कॉपी करें। आप किसी गूगल का भी पेटेंट उठा के उसको रिफ्रेश करके फाइल करके ग्रांट करवा लें, उसको कोई फर्क नहीं पड़ता। आप उसे स्टेटस पे लगाइए, लिंक्डइन पे लगाइए, उसे कोई फर्क नहीं पड़ता, वो गूगल है। बट फर्क उस दिन पड़ेगा आपने उनका कॉपी ना भी किया हो, आपने उनसे ही इंस्पिरेशन लेके हल्का सा मॉडिफाई करके कुछ अच्छी टेक्नोलॉजी बनाई हो। द मोमेंट आप 100 CR क्रॉस करेंगे, कहेंगे कौन है ये, तब वहां पे आप लीगल टेंगल में फंसेंगे। मीन्स आई विल से कि एकेडमिक्स के लिए चीजें बहुत ईजी हैं। यू कैन जस्ट गो फॉर फाइलिंग, यू विल गेट द ग्रांट, आपको कोई ऐसे कुछ छेड़ेगा नहीं। यू कैन डू कॉपी। मैं लोगों से कहूंगा कि अब जब मुझे क्वेश्चन नहीं आ रहा और मुझे मार्क्स अचीव करना है, इट इज ह्यूमन टेंडेंसी, और मेरे सामने वो आंसर है, मुझे दिख रहा है आगे वाला जो बैठा है उसने वो आंसर लिख रखा है, तो मुझे नहीं लगता कि कोई इतना रुक पाएगा कि नहीं नहीं ये गलत चीज है मैं नहीं लिखता। वो कॉपी करेगा ही करेगा। जब हमें पता है कि हमें ये चीज करे बिना अप्रेजल नहीं मिलेगी, प्रमोशन नहीं मिलेगा, तो हमें करना ही है। मैं भी करूंगा, कोई भी करेगा। इट इज अ ह्यूमन टेंडेंसी। हम अगर प्रैक्टिकल रहे तो वी विल गेट थिंग इजीली। तो लेकिन बात यह है कि अगर हम 100% कॉपी कर देंगे ना, देन वी विल इन प्रॉब्लम। रिसोर्सेस है, उन्हें यूज कीजिए, वो बने ही यूज करने के लिए। आई विल से इट इज नॉट बैड कि मैंने एआई की यूज कर लिया, चैट जीपीटी। इट इज बैड कि जिसे एग्जामिन करता है ना, उसे पता है कि आपने उसमें कितना खुद से इंप्लीमेंट किया है। क्योंकि हमारे पास डेली बेसिस पे कॉन्सेप्ट आते हैं एमटीआई पे, हेल्प पे हमें आइडिया हो जाता है कि ये उसका खुद का है या ये जनरेट किया गया है। कुछ लोग इतनी भी जहमत नहीं उठाते, वो उसमें कुछ करते ही नहीं है। इवन जो वो डॉट से पता लग जाता है, आपने भी शायद नोट किया होगा कि जब वो कॉपी करते हैं तो वो डॉट डार्क से वो ब्लैंक सा हो जाता है कुछ, शायद कभी नोटिस किया हो, तो वो उसको भी वो ब्लैंक ही रहने देते हैं। तो कॉपीराइट और डिजाइन में आप माइनर से ही मॉडिफिकेशन करेंगे, वो ग्रांट हो जाएगा। और इतना मुझे लगता है नहीं कि कोई एकदम 100% कॉपीड करे।
तो आप एआई डिटेक्शन करते हैं इसमें?
देखिए आईपीआर में एआई से कोई लेना देना नहीं है, क्योंकि मैं आई अगेन से, जर्नल का कॉन्सेप्ट अलग है। जब जर्नल कभी फर्स्ट टाइम आया होगा कि भाई पेपर पब्लिश होंगे, इसमें ऐसे ऐसे एक्स वाई जेड, वो जो बनी चीजें होंगी, पेटेंट इसलिए आया था कि कोई पैसे ना कमा सके। इन दी एंड मैं आपको बॉटम लाइन बता रहा हूँ, नो वन कैन अर्न मनी, नो वन कैन शो ऑफ कि ये मेरी चीज है। पेटेंट आईपीआर का इसलिए लॉजिक आया था। सो एआई प्लेगरिज्म नथिंग टू डू विद आईपीआर। आप करिए, खूब करिए, बस वो चीज पकड़ में नहीं आनी।
ठीक है ऋषि, थैंक यू सो मच।
Thank you so much, sir. So today's session highlighted that in the contemporary knowledge-driven world, creativity alone is not enough. Protecting, documenting, and strategically translating innovation into impactful solutions is equally important. The discussion on fundamentals of IPR helped us understand the significance of patents, copyrights, and design registrations in safeguarding original ideas, creative works, technological innovations, and design solutions. The session also provided a clear understanding of patent filing and documentation process, including strategies, procedural requirements, and the importance of clarity, novelty, applicability, and technical detailing in patent preparation. Another important aspect discussed was the transformation of research ideas into commercially viable and socially relevant solutions. The insights on future research pathways, interdisciplinary collaborations, and industry linkages reminded us that innovation thrives when academia, practice, technology, and policy work together. Overall, it encouraged all of us to view research not only as a scholarly contribution, but also as a potential catalyst for innovation, impact, and societal advancement. Thank you so much, sir, for your presentation today. I would request Dr. Ritaprita Ghosh, professor at Amity School of Architecture and Planning, Noida, to kindly felicitate the speaker. Good afternoon, everyone. Distinguished faculty members and dear participants, welcome back. As we arrive at the concluding session of this faculty development program, it is truly fitting that we end on a theme that connects research, innovation, and real world impact. It is my pleasure to introduce our speaker for the final yet extremely valuable session, Dr. Sonu Raghavan, Assistant Manager IPR Cell, Amity University, Noida. Dr. Raghavan has been actively engaged in promoting awareness and understanding of intellectual property rights and guiding researchers in protecting and translating innovative ideas into meaningful outcomes. Today's session on identifying patentable ideas and innovation potential, patent documentation and drafting techniques and patent filing procedures, as well as strategies, will provide practical insights into patents, claims, specifications, copyrights, and innovation protection. In today's research-driven environment, knowing how to safeguard original ideas is as important as generating them. The session today specifically focuses on the theme of copyrights. I'm confident this session will leave us on the valuable knowledge and strong perspective on innovation and IPR. May I now invite Dr. Sonu Raghavan to kindly address the gathering.
Good afternoon, all. Hi, this is Dr. Sonu Raghavan from Amity IPR Cell. And all of you have been introduced to copyrights, I think, in life. So I'm going to start the topic copyright, the importance of the copyright in India. My slides will cover the basic copyright definition, legal framework in India, and what is to be copyrighted, the rights of the copyright holders, duration of the copyrights, exceptions of fair deal, infringement and remedies, registration processes. So let's begin. What is copyright? Well, copyright is a form of intellectual property right that gives the creator of an original work exclusive rights for its use and distribution. These rights are basically protects the intellectual efforts of authors, artists, composers, and developers. The key point is that copyright does not protect an idea in the mind. It protects the expression of the idea, such as drawing, book, plan, photograph, music, software, code, film, lecture materials, and architectural designs. For example, the idea of designing a sustainable building is not protected, but the actual architectural drawing, plans, models, elevations created by an architect can be protected. Copyright protection is automatic once the work is generated. Registration is helpful, but it is not compulsory. Now let's talk about some legal framework in India. This slide actually mainly explains the Copyright Act, which was established in 1957, and after that there were so many amendments. And in 2012 there was a final fifth amendment, and it has been amended several times to cover new developments such as broadcasting, computer programs, digital content, and internet-based users. India is also a part of international treaties such as Berne Conventional, Universal Copyright Conventional, TRIPS Agreement and WIPO Copyright Treaty, which help protect Indian works internationally and foreign works in India. Now, what can be copyrighted? Under Section 13 of the Copyright Act, which suggests the following categories can be copyrighted under this act. Some of the literary works, which include books, articles, lectures, notes, computer programs, databases, and written content. These musical works, such as composition and notations. Artistic work, such as paintings, photographs, charts, maps, and architectural works. Dramatic works, which includes basically plays, screenplays, choreography, scripts, and direction. Cinematographic films. These films basically are a video content, which could be in the form of movies, documentaries, animations, and web series. And finally, sound recordings, basically music videos, music audios, and other sound recordings. For architectural students, and mostly important category is artistic work, under which architectural drawing, plans, layouts, sketches, buildings, sketches of the buildings within this category are copyrightable. Now, what are the rights of the copyright holders? Basically, there are two types of rights: economic rights and moral rights. Economic rights allow the copyright owner to commercially use the work. These include the right to reproduce, publish, distribute, adapt, and translate, communicate, perform, and license the work. For example, if you are telling about an architect who owns the copyright in a building plan, can decide who may reproduce or use the plan. The moral rights protect the personal connection between the author and the work. The author has the right to claim authorship and object to distortion or mutation of the work if it is harmful their honor or reputation. In Indian law, the core moral rights are mainly rights of the paternity or authorship and right of integrity. The right of withdrawal is not generally treated as standard independent moral under right Indian copyright law in the same way as in the foreign jurisdictions. Now let's talk about the duration of the copyright. Basically, duration of the copyright is 60 years from the death of the author, if we are telling about the individual author. For anonymous works, the term is generally 60 years from the date of publication. For architecture also, it is usually the same as that of the author's lifetime plus 60 years. That is, until when the author is alive, it is copyrightable, and after the death of the author, it is alive till 60 years. Now, there are some exceptions and dealings. Under Section 52, they provide certain exceptions. Permitted use may include fair dealing of private research, criticism, review, reporting, current events, education, examination, judicial proceedings, and certain library archive users. For teaching, this is actually important because limited use of copyright material may be allowed for the classroom instruction. However, copying entire books, paid notes, architectural plans, or online content and distributing them widely may still be an act of infringement. Now, let's talk about the remedies. What is an infringement? Infringement may occur when someone copies, publishes, distributes, sells, performs, communicates, or imports copyrighted works without your permission or the permission of the applicant or the author. These are some criminal penalties that is very, very deep inside. It is an extra, material, which I think if you are talking about the introduction to copyright, we need not to go to the criminal penalties and all. There are some certain remedies which are under certain jurisdictions, which we will have cover in some other presentation. Now, talking about the copyright registration in India, it isn't not a easy process, but still it can be done by anyone who wishes to copyright their work. First, we have to prepare the draft, and we have to make a login ID and the copyright website, and then we will have to fill the form 14 and then submit the documents, the relevant supporting documents, which contains both the NOCs. If the copyright is filed by the solely by a individual author, then there is no need to file the NOC. But if he is filing under certain institution or some company, then there needs to be a NOC from the concerned institution or the company. And after submitting the documents and filing the copyright and submitting the paying the fees, concerned fees of the copyright, that is 500 for literary art, literary artistic and this recordings. This is 500 and rupees 2000 in India. And for cinematographic work, it is 5000 rupees. And after filing, there is a 1 month period of waiting. That is waiting for the examination of the submitted works. And after the examination of the work, the Copyright Office releases a discrepancy letter, which we need to respond to. And if the examiner is satisfied with the response, they will register the copyright. Else they will again go for a hearing if needed. And then after the successful hearing or the prosecution in the hearing, the work would be granted or registered. The Designs Act, actually, somewhere while talking about the copyrights, this Design Act also comes into play, because when we are filing for the artistic work, there is a chance that the examiner will ask if, when we are submitting the um, kind of when talking about the architectural designs, we need to submit the designs, so outline designs. Then there is a question from the examiner that, do you have the design already filed in the respective work, for which there is a need if we are claiming for the commercialized purpose. That means the concerned design work is to be commercialized. Then there needs to be filed, designs need to be filed at that time. Else, if the copyright work is not related to design, or it's not related to commercialization, then we can definitely say ki designs is not needed, design certificate is not needed. Design certificate is basically needed when the commercialization comes into play, and majorly if we are publishing the or commercializing the design copyright more than in 50 numbers, then there is a need of design certificate. Else we need not to submit the designs. Now, copyright in architecture. Architecture is protected in artistic work, like I said, and the architectural drawings and plans, including blueprints, elevations, sections, site plans, and layouts are protected under the Copyright Act. The building or structure itself, where it reflects original architectural expressions, models and renderings, including scale models, 3D models, digital visualizations. These all are protected under copyright. An architect may retain moral rights even after transferring economic rights. Photographing or depicting the buildings in public places is generally permitted under specific exceptions. Reconstructing a building according to original drawing may be treated differently. Copying another architect's plans, drawings, or unique build form without permission can also lead to infringement. So, what are the main takeaways from this presentation? Is that the copyright is automatic and registration is not mandatory but useful. The Copyright Act is the main law that we need to follow. Copyright protects original expression and not merely ideas. Architectural drawings, plans, models, photographs, and buildings can be protected under copyright law. Copyright usually lasts with the author's lifetime plus 60 years after the death of the inventor. Thank you.
Thank you so much, sir. I would like to sincerely thank our speaker, Dr. Raghavan, for providing such valuable insights into copyrights in India and innovation in the field of architecture and design research. The floor is now open for questions and key discussions with the speaker of the day, who have joined offline, for participants who have joined offline and online. Participants who have joined online with us are requested to unmute themselves and ask the questions, or even may write in the chat box if there are any questions. Yes, sir.
Hello, sir. Like you mentioned, that copyright on the design or the building and even the drawings for the architects. So one of the example that I had was when I was in Punjab. You must be knowing there is a Burj Al Arab Hotel in Dubai. It's a very beautiful building, and it was a very remote place, not in the urban area, but in the outskirts, somewhere in the highway near Jalandhar or something. The form of the building is replicated exactly, but on a different scale. That building is somewhere about 60 floors, but the building that is replicated, the replica in Punjab is G+2 build. But the form is exactly the same. The color combination is exactly the same. So in that case, if the building is replicated somewhere which is not a very famous place, so does that the copyright issues exist there also?
Hello. Yes, definitely. There is a chance that infringement can occur at that certain times. But since you are saying ki, if the same replica, exactly same replica is there, but some of the dimensions are not, exactly as what is what or for the original this building, then see, copyright is basically the weakest form of the protection. So, so if any of the advancement that we can do to the present copyright work, we can again file with a new copyright form itself.
Only G+2, some kind of.
It will not, sir. Because if you have seen, there is one building in Pune also like this.
No, this is a pure replica of the Dubai.
Let me understand.
In the color combination, in everything is the same. So in that case, because very much located, they are not having any, say, financial advantage of replicating the form or something.
See, when there is no financial gain
Benefit
in that,
gain.
benefit in that, then there is no item. Then
Okay.
there is no problem with the copyright holder.
There has to be a financial gain to
Exactly.
the beneficiary, then only I can,
There has to be, it has to be commercialized,
it has to be commercialized.
commercialized.
जैसे प्रोड्यूस वाले करते हैं ना कि सलमान खान के हाथ में दूसरे ग्लास होती है लेकिन सेम टाइम बच्ची
Unless and until it is not commercialized or it is not gaining any exactly.
बड़ी कंपनी को टेंडर हो
Unless and until जब वो उनको हैम्पर करने लगता है कि उनके सेल्स कम हो जाते हैं इनकी वजह से, then they can definitely sue the other one. Basically for commercialization. Issue using of bad implementation of law is for commercialization. That is very specific, but in actual, we can do the implementation, it is not for that. It's for financial.
Thank you so much, sir. Do we have any other questions? We have one more question.
One question is like, I just wanted to know what is the process? Like, there's a patent ke liye we know the process, the form and the criteria what we are basically required, right? But for the copyright, we don't know how to process that. So what is the criteria?
Well, just like patent,
Hmm.
copyright also has a template forms.
Mhm.
Which you can first need to send us the copyright work that you are
Okay.
copyright.
Mhm.
Then after we will give you the template forms.
Okay.
Then we will have to fill that forms and then we will.
Okay.
It's a form 14.
Mhm.
So there is an NOC because and is the applicant, so there has to be.
Okay. Okay.
Assigning applicant, as in applicant.
Okay. And also, what is the time frame to accept the copyright?
See, there is 1 month and date is there.
For filing?
So minimum 1 month is there. And say, as soon as the examination happens and discrepancy is solved. So maximum
Okay, so from the filing to the acceptance. Okay.
तीन ही फ्लोर है देखो ना विंडो की कितना चलेगा तो दोनों फ्लोर की भी लाइन दे दो
Thank you so much, ma'am. Thank you so much, sir. I would like to take this opportunity to thank Dr. Sonu Raghavan for such an insightful and engaging session on copyrights in India. Your presentation has helped us understand that copyright is not merely a legal framework, but an essential tool for protecting creativity, originality, and intellectual effort in today's knowledge-driven world. The discussion on ownership, authors' rights, infringement issues, fair use, and the practical relevance of copyrights in academia, creative, and professional domains was extremely informative and thought-provoking. As educators, researchers, designers, and professionals, this session reminded us that innovation and creativity gain true value when they are ethically protected and responsibly used. In an age of digital sharing and AI-assisted content creation, awareness of copyright laws has become more important than ever before. On behalf of the organizing committee and all participants, I would like to extend our sincere gratitude to Dr. Raghavan for sharing his valuable expertise and time with us. Thank you, sir. I would request Dr. Ritabrita Ghosh, Professor at Amity School of Architecture and Planning, to kindly felicitate the speaker.
It's not a it's a world book.
Very much.
Thank you so much, sir. I would request all participants to kindly switch on their cameras so that we can take the attendance and a group photograph. This is for participants who've joined online with us. Can I request all the participants who've joined online with us, can they please switch on their cameras so that we can take one photograph?
All the online participants, please open your camera for the attendance purpose. And on the basis of this also, we'll
Process your attendance.
attendance. One. It's on. On क्यों किया गया? अभी किया मैंने अभी किया You also take Wait for 2 minutes.
I would request everyone to just please be patient for a minute. We're just clicking a photograph. Thank you so much. Thank you so much, everyone. I would now like to invite Dr. Snigdha Chaudhary to kindly address the gathering.
So as we came to the conclusion of the enriching 5-day faculty development program, it gives me immense pleasure, satisfaction, and pride to reflect upon the insightful learning, meaningful discussions, and valuable academic interactions that have been taken place throughout the program. The faculty development program on blueprint through breakthrough research methods, techniques, and in architecture successfully brought together with the distinguished academicians, researchers, professionals, and participants to explore diverse dimensions of research and innovation in architecture and the allied disciplines. Over the past 5 days, the program covered a wide range of significant themes, including research design, research ethics, data-driven methodologies, artificial intelligence and research, literature review, techniques, bibliometric analysis, design thinking, qualitative research, quantitative research approaches, research proposal design, development, intellectual property right, and patent documentation and copyright thing. Each session was thoughtfully curated and delivered by the eminent resource persons who share their expertise, experience, and valuable insights with the participants. So the interactive discussions, question answer sessions, and collaborative learning environment made the program highly engaging and academically enriching. The FDP not only strengthened the participants' understanding of advanced research methodology, but also emphasized the importance of innovation, interdisciplinary learning, and the practical application of research in architecture and built environment. We sincerely hope that the knowledge gained during the program will inspire participants to understand meaningful research, contribute towards academic excellence, and develop innovation solutions addressing the contemporary architectural and societal challenges. On behalf of MIT School of Architecture and Planning, I, Dr. Snigdha Chaudhary, respected dignitaries, express our heartfelt gratitude to all the respected dignitaries, participants, and the resource persons who physically present and present through online and support all our valuable support and active participation in the making the faculty development program a grand success. I would also like to thank all the faculty members of Amity School of Architecture and Planning, research scholars, and the other participants who joined through online for the valuable and meaningful interaction during the session. A special note of appreciation to our director sir. Without the director sir, technical team, and the IT support staff, without whom this dedicated program will not be completed. So thank you. I would like to request Dr. Ghosh to conclude the session. Also, we are sharing the MCQ link with you. Just make sure that your MCQ will be submitted before time, like which is like by 5 p.m. Thank you.
Thank you.
अब हमारी टीम आएगी आपके पास तो you need a camera.
Yeah. So good evening, everyone. As we conclude the faculty development program on Blueprint to Breakthrough, Research Methods and Techniques in Architecture, organized by Amity School of Architecture and Planning, I extend my sincere gratitude to all our distinguished speakers and participants for making this FDP highly insightful and enriching. By name, I should express my gratitude to all the distinguished speakers. Dr. Ekta Singh, Dean DIT University, for her enlightening session on research design, emerging methodologies, and academic integrity. Dr. Krishna Kumar Dhote, Dean MNIT Bhopal, for sharing valuable perspectives on quantitative and qualitative research approaches. Dr. Kuldeep Kumar, Associate Professor, ASAP Noida, for his session on literature review and research framing. Dr. Niharika Kusawa, postdoc researcher, for discussing contemporary research tools and techniques. Dr. Shalin Singhal, Director and Professor, Terry School of Advanced Studies, for his insightful deliberation on sustainability-oriented research. Dr. K.K. Pandey, eminent built environment expert and ex-IIPA and ex-HEDCO expert, for guiding us on policy and governance dimensions in research. Dr. Satyaki Sarkar, HOD, Department of Architecture, BIT Mesra, for his session on urban and architectural research practices. Dr. Anurag Verma, Executive Director, founder Nirmana, for highlighting professional and practice-based research insights. Dr. Harish Sharma, Deputy Manager, IPR Cell, Amity University, Noida, for his valuable talk on intellectual property rights. And finally, Dr. Sanu Raghavan, Assistant Manager, IPR Cell, Amity University, for his interesting and informative presentation on copyrights in India. I express my gratitude and gratefulness to the Amity University management and VC ma'am, Dr. Sukla, for encouraging us to conduct such events. And I also express heartfelt thanks to our respected chairperson, Professor Dr. Dr. Balwinder Shukla, and convener, Professor Dr. Devendra Pratap Singh, for constant guidance and support, and also the program director, Dr. Snigdha, along with her organizing team, and a special mention to Lavaditya for conducting the program so smoothly. IT team of Amity University has done a great job linking us throughout the event with all corners of the country. Thank you very much. And I would like to thank Sagina Huda for the invaluable support. Finally, I thank all the faculty members, participants, both online and offline, whose enthusiasm and cooperation made this FDP a grand success. Thank you all, and wishing everyone continued success in research and academics. Thank you.
Once again, thank you everyone for your valuable presence and contributions. With this, we officially conclude the faculty development program on Blueprint to Breakthrough, Research Methods and Techniques in Architecture. Thank you to all the dignitaries, speakers, participants and organizing members for this program, a grand success. Have a wonderful evening ahead, and I'm just sending the MCQ. Make sure you fill the MCQ before 5 o'clock. Okay. Thank you. No, on WhatsApp. We are sending the link through WhatsApp. Okay. Thank you.